I'm Tom Downs, and I'm here with Patty Perez, who's an associate at the firm. And we work on wills, trusts, and estates. That's basically the work we do. And part of that work is making sure that accounts like IRAs, 401ks, life insurances have proper beneficiary designations, because although the beneficiary designation may not go through the court process, it may not go through your will, if it's not coordinated with the planning, you could have a big disparity between what you wanted to have happen and what actually happens. And I think you ran into something we talked about.
Absolutely, absolutely. One of the first nightmare scenarios that I learned about when I first began at the firm was a woman came in to meet with Tom. Her husband had passed away. He passed away with a will. He had left everything to her in the will. Unfortunately, when Tom explained to her how beneficiary designations work, the look on her face told him exactly what had happened. Unfortunately, the husband had left his ex-wife's name on his IRA as the designated beneficiary, so none of that went to his current wife.
Well, and a lot of people think that the will overrides what the beneficiaries say, but that's not true. I had a young woman who had cancer, and we were working on a will for her son, and her son was 2 years old. And we did the will. We had a trust set up in the will for taking care of the child until he was 25 years old. We had her change her life insurance, her retirement plan into that trust. So when she died, it was in the hands of people she had confidence would take care of this young boy. But unfortunately, she missed an account. There was an account that had about $60,000 in it that had no beneficiary on it. And so therefore, when that child turned 18, he got $68,000. He actually got $68,000 plus the interest on $68,000. And it was not an ideal situation for the people who had a rather unruly young man they were trying to influence. And so, part of the planning is just making sure that the people you want in charge are in charge for as long as you want them in charge. If you miss something, we're not all perfect, but if you miss something, it can leave a gap in the planning.
Absolutely. It's a matter of designating those beneficiaries and keeping it updated, because sometimes people predecease us.
Well, another point there is retirement plan beneficiary designations. We have gone through an evolving set of rules about how to do that. And we used to say, hey, make the trust the beneficiary. Depending upon the age and capacity of the people, we may now say, no, make your children the beneficiary, or make your spouse and then the children beneficiary. If you haven't visited those choices in the last 4 or 5 years, you really should contact us, because the advice we may have given you before might not apply. There was a very significant change in the law in 2020 called the Secure Act, which basically said if you're inheriting an IRA, it went from your whole life expectancy to take the money out to only 10 years for most people. And that could dramatically affect your planning.
Absolutely. So especially even if you've already done your estate planning, if it's been quite a while since you've done it, you need to come in, because the laws change, as does your family situation.
Absolutely.